living in the United States and paying attention to news at all, then you know that the case against Apple, the order against Apple, ordering it to unlock a phone that is at issue in the San Bernardino terrorist action that the Justice Department would like to access to attempt to see what information is on it. That order has been vacated. And that as of today, as I understand it, the Justice Department has actually gotten into the phone. The FBI has gotten into the phone using a third party, as they told the court that they were attempting to do. And so Apple is now off the hook, does not have to unlock the phone. The order against it has been vacated. Its motion to vacate the order against it is no longer pending. There will not be a hearing on all these issues that have been in the news for the last several weeks. So it's a bit anticlimactic, but the issues at the heart of this dispute go on. And certainly the fact that there's been such a wide-ranging discussion about these issues is going to shade what happens next, whether that happens next in another court somewhere in the United States, or whether what happens next is legislation designed to address this tension between having strong encryption on devices and law enforcement and the government being able to do its job. So here we are. We know that Apple is no longer under order. We know that there's been a lot of discussion about this, and that it's really just the tip of the iceberg on the issue. This is going to come up again. It has come up before. And so what we need from our lawmakers is some sort of guidance that makes sense and doesn't put courts in the position of having to order parties to do something that may well be unconstitutional, as many arguments were advanced in this case and would have been advanced had it been continued. Derek has written a great article, actually, about our constitutional drafters, our founders in the United States, and what they would have thought about this whole dispute. Derek, can you fill us in?
Sure. Well, I mean, this case brings up a lot of really interesting constitutional questions and law questions, and some commentators have argued that the law in question, which is the All Writs Act, is simply too old to be applicable. And that didn't actually make much sense to me, because I said, well, the Fourth Amendment is just as old, I assume. So I started doing some research on it, and it turns out that they are basically just as old. And that when the founders passed the All Writs Act in 1789 as part of the First Judiciary Act, the very next day after Congress, after it was enacted into law, the President of the the day after it was enacted into law and signed by the President, Congress passed the Fourth Amendment the very next day. And so what I did was started to examine the history. And there's a long history in the United States of being very skeptical of these writs. In fact, founding father James Otis wrote about these writs as being odious and leading to tyranny. And that was really part and parcel when the founders were writing the Fourth Amendment. And so my article kind of examines this history and how the All Writs Act is actually much more circumspect than the predecessor, which was being abused by the king. And a lot of the rhetoric we've been hearing through the FBI has been that the government has some sort of a right to access any communication at any time. The idea that if there were something off limits from the government, that's dangerous and that's unprecedented. Well, the reality is that it couldn't be more false. Thomas Jefferson himself was a cryptographer. And what I discovered was that in the founding era, there were these two locks, one of them called the Brahma lock, and it was completely unpickable. And this lock existed like that from the 1770s through the 1850s. And authorities literally could not access anything behind one of these locks. And that was the context in which they passed the All Writs Act. So with that context, it really forces us to take a different perspective on the All Writs Act. And all the law actually says is, a court can issue a writ in order to for necessary purposes. It's a very limited, circumspect piece of legislation. that really shouldn't be used in the manner that the FBI was trying to do so here.
Well, I'm kind of at sea as to your conclusion there, and I want you to talk through it a little bit more, because weren't we also in a situation of an unpickable lock here? So why is it not similar?
No, it is similar, but in the unpickable lock in the 18th century and the 19th century, no court ordered the creator of the all-pickable lock to go out and assemble a master key where no master key existed. But yet that's what the government was trying to do here. They're saying under this 18th century law, Apple needs to create a master key where one effectively doesn't exist. And you may say, well, it's not exactly a master key, but it's effectively the same thing as a master key. It would have enabled the FBI to access any iPhone. And that's just not consistent with the history of the law.